status of a third party, which could not bring the case itself in its own name. Madam President, members of the court, begin with the question of fact. The written pleadings set out the contents of many documents, giving details of dealings between the Gambia and the OIC and its other member states leading up to these proceedings. These documents show that in May 2018,
It is an honor to appear before you and to do so on behalf of the Gambia. I will address Myanmar's first preliminary objection. This objection, in effect, asked the court to erase the Gambia's name from its application and to replace it with the Organization of Islamic Cooperation on the asserted ground that the OIC and not the Gambia. On the basis of this substitution, Myanmar argues that the court lacks jurisdiction because only states and not international organizations may be parties to disputes before the court, or alternatively, that the application is inadmissible for the same reason. The objection lacks any basis in law or fact. I begin with the law. The relevant requirements for the court to exercise jurisdiction, ratione personae, are clear and straightforward. They are rooted in Article 92 of the UN Charter, which provides that the court shall function in accordance with the UN, with its statute. The pertinent provisions of the statute are located in Articles 34 and 35. Paragraph 1 of Article 34 provides that only states may be parties in cases before the court. Paragraph 1 of Article 35 then provides that the court shall be open to the state's parties to the present statute. Tellingly, Myanmar did not mention Article 35 on Monday. That is perhaps not surprising. The provision is fatal to its argument. Article 35's use of unqualified mandatory language, shall be open, permits no exception to the requirement that the parties to the statute are entitled to have access to the court. Since Article 93, paragraph 1 of the Charter stipulates that all member nations are ipso facto parties to the statute, the Gambia, by virtue of its UN membership, is ipso facto a party to the statute as well. Accordingly, by operation of paragraph 1 of Article 35 of its statute, the court shall be open to the Gambia. Since both the Gambia and Myanmar are parties to the statute of the court and also parties to the Genocide Convention, the Gambia is entitled to invoke the court's jurisdiction in accordance with Article 9 of the Genocide Convention. This, Madam President, should be the end of the matter. So how does Myanmar try to fashion its objection? As you heard on Monday, it advances the novel argument that the court can disregard the fact that the Gambia is the applicant and decide that some other entity is the real applicant. As you will have noticed, Myanmar cannot cite a single instance in which this court or its predecessor, or indeed any international court or tribunal, has ever suggested, let alone denied, that the applicant state is the real applicant. Nor, as far as the Gambia is aware, has any respondent state ever before asked the international court or tribunal to do so. Myanmar cannot even cite a single commentator, anyone, who supports this unprecedented theory. The reason is plain. Under Article 35, Paragraph 1, states that are members of the United Nations are entitled to seize the court in accordance with an applicable basis for jurisdiction, such as Article 9 of the Genocide Convention. As Professor Rosen has observed, every state which is a party to the statute has the right to invoke the jurisdiction of the court in accordance with the general conditions for the exercise of that jurisdiction. It was precisely this right that the Gambia invoked when the Gambia commenced the present proceedings. Myanmar had nothing to say on Monday about Professor Rosen's commentary on jurisdiction. Myanmar, nonetheless, asks you to ignore the application and attempt to discern why, or on whose alleged behalf, the Gambia commenced these proceedings. Now, putting aside the fact that the Gambia brought the case because it has a dispute with Myanmar regarding its violations of the Genocide Convention, a matter to which I will return, the question of what motivated the Gambia to commence the case is wholly irrelevant as a matter of law. As the court held in paragraph 52 of its judgment on jurisdiction and admissibility in Nicaragua v. Honduras,
Alhamdulillah, ತುಂಬಾ ದಶಮಾಲಾಗಿರ
with the political motivation which may lead a state at a particular time or in particular circumstances to choose
video
to
the
show
haranna ba ende
itself.
kana comment gare yasai
The court's case law has thus been clear that it does not matter whether the Gambia's motivation for bringing the case was its outrage over Myanmar's genocidal acts, the urging of other members of the international community, a proposal by the OIC, or any other reason. As the court held, none of this has any relevance for the exercise of its jurisdiction. There is good reason for this. As Professor Tamuchat has observed, the court's holding that any possible political motivation of an application is irrelevant for the discharge of its judicial function would seem to be the court's final word on the issue. That is because Professor Tamuchat further observed the court would emasculate itself if it refrained from agreeing to clarify the legal position in disputes related for peace and security. Myanmar did not address Professor Tamuchat's commentary either. So, how does Myanmar make its argument? On Monday, while conceding that the applicant's motivation is irrelevant to the exercise of jurisdiction, Myanmar argued that its objection is not based on the Gambia's motivation, but rather on whether the Gambia is the real applicant. This artificial formulation provides Myanmar no help at all. Myanmar's thesis for why the Gambia is not the real applicant depends on proving that the Gambia commenced the case at the OIC's behest, rather than for its own reasons. That is inevitably a question of motive, the very definition of which is a cause or reason that moves the will and induces action. As the court has ruled, such factors are irrelevant to the exercise of its jurisdiction or the admissibility of an application. Nor is Myanmar helped by arguing, as it also did on Monday, that whether the Gambia is the applicant is a question of substance that calls for objective determination. Even if that were correct, all the court would need to determine objectively is whether the Gambia is a party to the statute of the court. The UN Charter specifies how this is done. Parties to the Charter are ipso facto also parties to the statute. So, to the extent there is anything to be objectively determined, it is accomplished by verifying that the Gambia is in fact a member. The requirements for jurisdiction ratione personae are satisfied. For the court to decide otherwise would be truly extraordinary. Turning now to the facts. The Gambia is, by any measure, the real applicant. On Monday, Myanmar tried to cast doubt on that reality by referencing an eclectic variety of websites, articles, tweets, and press releases. But Myanmar deliberately glided over the evidence that matters. And in making this argument, it was surprising to hear its counsel contend that the Gambia has said nothing about the events leading to the case. That is simply not true. So let's begin with what the Gambia has in fact said about the case. Madam President, the then agent and Attorney General of the Gambia, Mr. Abubakar Marie Tapadu, himself a former war crimes prosecutor at the International Criminal
Record not.
told
This
the
should
court
be good side.
why the Gambia brought the case and how it came about when he addressed you at the opening of the provisional measures hearing. He explained this in very direct terms. He recounted how he had visited the refugee camps in Bangladesh as part of an OIC delegation, and how, as he listened to the stories of the refugees, he could smell the stench of genocide from across the border in Myanmar. And he explained how he heard stories of helplessness in the face of mass killings, of mass rape and mass torture, and of children being burnt alive in the sanctuary of their homes and places of worship. The stories of these victims, the Gambia's agent told you, were all too familiar to me from a decade and a half of interaction with surviving victims of the Rwandan genocide. He further explained why the plight of the Rohingya had a particular resonance for the Gambia and why the Gambia was motivated to act. He told you 22 years